A huge decision out from the Supreme Court dealing a huge blow to affirmative action. In two separate decisions, the court struck down race-based admissions programs at both Harvard and the University of North Carolina. This is a massive, massive blow, not only to affirmative action, but to the left, and I think is going to have a profound impact well beyond college admissions. Now, Edward Bloom, who leads the group Students for Fair Admissions that led the challenge to both the Harvard and the UNC policies, said that this decision, quote, marks the beginning of the restoration of the colorblind legal covenant that binds together a multiracial, multi-ethnic nation. No surprise there, by the way, that all three liberals on the court voted against both of those decisions. It was Chief Justice John Roberts who wrote for the majority in the case, stating profoundly the following: eliminating racial discrimination means eliminating all of it. Now, that to me is the real critical line in these decisions. See, the left claims to want to end racial discrimination, but the very remedy that they use has always been just another form of racial discrimination. If you think back, prior to the ruling, colleges and universities had always used a prior Supreme Court ruling that allowed race to be used in admission as long as it was one of many factors determining admission. Chief Justice Roberts cited the 14th Amendment's Equal Protection Clause as the basis for the majority's ruling. He wrote, "The Harvard and UNC admissions program cannot be reconciled with the guarantees of the Equal Protection Clause. Both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints." Key line there, meaningful endpoints. "We have never permitted admissions programs to work in that way, and we will not do so today." Clarence Thomas wrote what they call a solo concurring opinion. That means that he wrote a separate opinion, but he agrees with the majority. His opinion ran 58 pages. To put that in context a little, the Chief Justice's majority opinion was only 40 pages. But here's what I want to get back to. Thomas, in his opinion, effectively overruled the court's 2003 decision that was called Grutter v. Bollinger, which permitted for the limited use of affirmative action, but said it should be wound down within 25 years. That's exactly what the Chief Justice was talking about. It's one thing to right or wrong, but not indefinitely. In his opinion that Thomas wrote, he said the court's opinion rightly makes clear that Grutter is, for all intents and purposes, overruled. It sees the university's admissions policies for what they are: rudderless, race-based preferences designed to ensure a particular racial mix in their entering classes. Those policies fly in the face of our colorblind Constitution and our nation's equality ideal. In short, they are plainly and boldly unconstitutional. Now, interestingly, the rulings were 6-3 and 6-2. Why? Because Ketanji Brown Jackson, who was the appointee of Joe Biden, recused herself from the Harvard case because she had served for years as one of Harvard's governing boards. But she did participate in the North Carolina case, why that one is 6-3 and the Harvard one is just 6-2. Now, Justice Sonia Sotomayor wrote herself a 69-page dissent saying, "Today, this court stands in the way and rolls back decades of precedent and momentous progress. It holds that race can no longer be used in a limited way in college admissions to achieve critical benefits. In so holding, the court cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter." So it would seem that she actually wants this to go on limitless. By ending race-conscious college admission, she continues, this court closes the door of opportunity that the court's precedents help to open to young students of every race, a requirement designed to ensure all racist conscious plans fail. I don't think that's true. Jackson's dissent offered a full-throated defense, as you can tell, of this race-conscious practice in college admissions as a way to remedy past and ongoing discrimination. But as I said, she seems to think that it should just go on indefinitely. Interestingly, side note for those SCOTUS enthusiasts out there, if you're a big court fan, both Justice Thomas and Jackson read portions of their opinions out loud from the bench as the opinions were being delivered, which is a rather unusual practice reserved for when a justice has a strong personal feeling on an opinion that's being cast. But it wasn't one of the justices that caught my eye. It was Ben Carson who I think summed it up best when he wrote on Instagram, "Today's opinion out of the Supreme Court ruling affirmative action as unconstitutional is a massive win for achieving real equality in this country. Are we a perfect nation? No, but your skin color, sex, and religion do not determine your outcomes in life. Hard work and determination do. We are not a nation of victims. We are a nation of opportunity. This opinion ensures that everyone will have equal access to those opportunities. We have made tremendous steps in the right direction in terms of racial equality in this country, and today's opinion both acknowledges and furthers that progress. There should always be equal rights, not extra rights." Well said, Ben Carson. Well, if you enjoyed this video, click the like button, subscribe, and ring the bell to make sure that you never miss another video.